Hi there, I'm James Dapperty, and this is Coffee and a Case Note. Team, today we're going to talk about Uniform Civil Procedure Rule 42.20 and the dismissal of Supreme Court litigation. And if that sounds a little bit fiddly, don't worry, we're going to work through it together and we'll figure it out. We have a plaintiff. As we know, plaintiff is someone who kicks off legal proceedings. We have a defendant, and as we know, a defendant is someone who responds to the plaintiff's claim. The plaintiff says, hey, me and the defendant entered into a deed, and that deed related to a drainage easement, a right for me to have some drainage flow through the defendant's property. And essentially what the plaintiff seeks is specific performance. The plaintiff says, I want the court's help to make sure the defendant does what it promised to do. So litigation starts. Now, shortly after litigation starts, the plaintiff and the defendant agree together to sit down and it's fun to get a phone call in the middle of recording these things. Sit down together and agree that the proceedings ought to be dismissed. Now, dismissed, I'll ask you to hang on to that word. Now, the only thing they do not agree on is who is to pay whose legal costs. And in the scenario here, we're going to refer back to that rule that I mentioned earlier, Rule 42.20 of the Uniform Civil Procedure Rules. Now, what that rule says is, if proceedings are dismissed, then the plaintiff is to pay the legal costs of the defendant unless the court makes some other order. And so what we're talking about today is an argument between the plaintiff and the defendant about whether the defendant is going to have its costs paid, which is the usual position, if we can put it that way, pursuant to the rule, or whether the plaintiff is going to be able to convince the court to make some other order. The facts are quite interesting. Now, and they're also quite fiddly. We have this deed, and what is interesting is that it takes a bit of time for the deed to get executed, and there are various counterparts to the deed or different copies of the deed which once executed will form the one document. And it's a bit unclear when one party signed it and when the other party signed it, and there's a bit of back and forth. And essentially what the plaintiff says is, defendant, you engaged in unreasonable delay in relation to the entry into of this deed. Now, what the defendant says is, well, plaintiff, you weren't in a position to show you were ready, willing, and able to proceed with the deed because you hadn't paid this $800 invoice that had to be paid pursuant to the deed, so you shouldn't have commenced proceedings, right? Plaintiff saying defendant was too slow. Defendant is saying plaintiff hadn't done everything it had to do. And so the court had to figure out what to do in this scenario. And what's interesting and occasionally a little bit challenging when dealing with costs judgments of this sort is the court weighed the argument of the defendant, weighed the argument of the plaintiff, said that it was not unreasonable for the plaintiff to have commenced the proceedings because of the defendant's delay, said that also it noted the defendant's argument about the plaintiff's failure to pay that $800 invoice, and having reflected on all of these issues, decided that each party ought to pay its own legal costs, which means that despite the primary position in Rule 42.20, the court otherwise ordered, that otherwise order was, you can each pay your own legal costs. Hope that decision assisted you and that discussion assisted you, and look forward to speaking again soon. Cheers.